Great. Right. Well, we'll kick off. Good afternoon, and welcome everyone to Keating Chambers and Pinsent Masons webinar, which is on the Supreme Court's decision in Finch. I'm delighted to have three experts with me today who've spent the last 4 days absorbing the judgment and considering its potential implications. So they are Lord Charles Banner, who's King's Counsel at the Keating Chambers. He's advised on a wide variety of development proposals, and very relevantly has been involved in judicial reviews concerning GHGs in relation to Heathrow and HS2, and has also recently submitted his independent report on judicial review in infrastructure consenting context. And then second, we have Imogen Dewar, who's a senior associate at Pinsent Masons. She specialises in consenting major energy and infrastructure projects, focuses on greenhouse gas and habitats aspects, and day in, day out, she's advising projects on the GHG aspects of scoping, assessment, and consenting development. And she's also acted on a number of climate-related judicial reviews of DCO schemes. And last but not least, I have Matt Fox, who's also a senior associate at Pinsent Masons. He's advising particularly on consenting major energy infrastructure projects and focuses a lot on EIA. His career has encompassed working on some of National Highways and TfL's biggest schemes, and subsequently advising on solar, carbon capture and hydrogen DCOs, as well as the country's largest flood alleviation scheme, he tells me. So we will, in terms of format, hear from each of them and then move into the discussions. Please do submit questions you have via the Q&A button, which should be on the bottom row of your Zoom screen. And we will do what we can to get through those, as many of those as possible. We're down for about an hour. I will endeavour to stick to that. Before we hear from Charlie, Matt and Imogen, it's worth me just briefly rehearsing why we have this judgment last Thursday. It started with an EIA scoping report from the developer in mid-2018, can you believe it, in relation to a proposed expansion of an oil well in Surrey. So then in September 2019, the County Council had considered the subsequent planning application and resolved to grant consent. The environmental impact assessment considered the greenhouse gas emissions arising from the extraction of oil at that site, but not its subsequent refinement or ultimate combustion. Ms. Finch brought a claim for judicial review on various grounds, including that the County Council's grant of planning permission was unlawful, as that EIA should have considered the downstream GHGs arising from combustion of the oil. The High Court and Court of Appeal, for different reasons, but both dismissed the judicial review. And now, over 5.5 years after the scoping report, the Supreme Court has allowed Ms. Finch's appeal. And the only ground the Supreme Court considered was that relating to the lack of assessment of those downstream emissions. The judgment was by a majority of 3-2. But today, our focus is very much on the practical implications of the judgment of the majority, and not on any questions of moral or policy questions that may arise in relation to the issues. But enough from me. Let's move on to hear from our three on the panel today. Matt, can I hand over to you first, please? He's going to pick up on some of the key practical takeaways from the judgment. Matt.
Thanks, Nick, and good afternoon, everybody. So this judgment, 100 pages long, and what both judgments do, both majority and dissent, is talk through kind of the starting point of the EIA directive and the EIA regulations. And in the majority judgment, it's clear, the reminder that in an ES should only be based on information on which a reasoned conclusion can properly be based, to determine if an effect can be considered to be a likely significant effect to the development. And there's quite a lot of discussion around what does likely mean and how does that enable you to reach a reasoned conclusion. The focus is that the EIA is future looking, and because you need to have an understanding of what is a likely effect in that future, the reasoned conclusion that you're reaching can't be agnostic or based on some form of conjecture. So the key phrase that I think everybody has picked up really here is that the key question is whether there is an inevitable causation between the development in question and the effect under consideration. Now, the judgment in the majority talks about the common legal principle of the but-for test, and talks about whether you should expand that or simplify it. But the key point is that the assessment should be considering whether there is a sufficient, more than just a sufficient causal connection, which is something that the Court of Appeal had talked about, but actually something there's an inevitable link between event Y and event X. It's clear that this will need to be considered throughout the EIA process. Obviously, Nick mentioned that the case was about scoping, and so this question needs to be asked from that point on onwards. And crucially, the court recognises that question about scoping and at decision making is an evaluative judgment where decision makers may differ. So immediately the court is recognising that question, it may be a matter of planning judgment, but it is something which could lead to different conclusions being made by different decision-making authorities. Now, obviously, this case focused on the fact that there is inevitable causation between the oil that was extracted at the Weald site and its ultimate combustion, notwithstanding what happens in between. And the court differentiated that from steel being used, it is produced and then is used to produce aircraft as part of the production process for aircraft, and how in the court's eyes that there is a difference there, because how can you be sure, how could you possibly calculate the emissions that arise specifically from that piece of steel in one piece of aircraft when there are many aircraft and many types of material that are used in producing that aircraft. So that's the key point. It's inevitable causation. And I think, but when this all needs to be seen in the context that this was all about what you should be reporting on in the ES. And just because it's in the ES does not impart that information has to be treated in any specific way, whether negative or positive, and it not necessarily a reason to refuse consent. And the court was at pains to say that what we're talking about here is what should or shouldn't be in your EIA, and nothing further than that. I'm going to just pass to Imogen now, who's going to talk about what the court talked about in terms of what you can take into account in trying to determine whether inevitable causation actually is taking place.
Thanks very much, Matt. Hopefully everyone can hear me okay. So I think this is going to be the key practical question that developers and applicants will now be asking themselves in carrying out their assessment, in scoping their projects. What are the factors in determining whether there is this inevitable causation? I anticipate there's going to be a huge level of discussion that's ongoing with this, and I think one thing that the industry really needs to do is work with EIA practitioners to understand what the methodologies might be, and that may well be on a sector by sector basis. So lots of discussion ahead. What I thought it might be useful for everyone this afternoon is to start to sketch out the sort of key messages that I think come from the judgment that give an indication of the consideration, the thoughts that should be given into that inevitable causation question. So the first case and that Matt's outlined there is about causation and methodology, and critically whether an agreed and accepted methodology already exists. So it's important that in this case, in the case of Finch, an oil extraction facility, the parties had agreed during the proceedings that in this development, a methodology was agreed whereby the emissions could be assessed. So that methodology was in existence, the parties had agreed as existed, and the parties had also agreed that the causation of the effect existed. So they had agreed that the combustion of the extracted fuel, oil, would give rise to the emissions. So the parties had agreed the causation and agreed that there was a methodology. That may not well be the case for other types of development where the methodology is more unclear. That's the grey areas where discussion will be required. But in this case, there was a methodology. Secondly, the court went on to talk about whether or not there's an intermediate process. So here, there was a question over whether the fact that the oil will need to be refined before it then goes on to be burned and to release the emissions. The court held that in this case, that refinement was not an intermediate process that broke the chain of that inevitable causation. And that was the case here, because refinement of the oil does not change its basic nature or its intended use. So you've extracted oil. The fact that it is refined does not change the fact that essentially it's a hydrocarbon that will be burned, that will give rise to emissions that disperse to the atmosphere. So the intermediate process here does not change its basic nature. Therefore, that intermediate process in this case did not break that inevitable causation. Thirdly, the court went on to deal with the question of whether there's an activity that takes on off-site out with the red line boundary. Again, the court held the fact that an impact occurs off-site outside the red line boundary does not prevent it from being an indirect effect of the project that requires to be assessed in the EIA. The court also went on to talk about other environmental regimes, and this in particular may be of interest, that where as part of your project there is the existence of another environmental non-planning regime, such as an environmental permitting process, you will assume that that environmental permitting process can operate effectively to avoid or mitigate the effect. However, the existence of that other regime does not remove the obligation to identify and assess the effects within your EIA for your development. So you cannot park your assessment because there is a separate environmental or other non-planning permitting process. And the key point that the parties that came out in the judgment in this case is, like I've been saying, it was capable in this instance to make that assessment. The information was available. Critically, the court was at pains to emphasise that EIA does not require attempts to be made to measure or assess putative effects that are incapable of assessment. And I think that's what's going to be really key here, and that parties will be relying on, is whether it's capable of making that assessment or whether the information simply doesn't exist to do so. And one other point that I wanted to pick up, which I think will be of interest to those listening, is that the courts said that this comes down to whether there's any sort of double assessment that can be made. So whether in your application for your assessment, there may be an effect which actually would arise under another application for a different assessment, and there may be some sort of assessing of effects simultaneously across several different applications. The court said that there's no rule in principle that would prevent that assessment taking place under multiple different applications. They saw this as consistent with the EIA objective that effects should be assessed at the earliest possible opportunity, the earliest possible stage in a development. So those are sort of key principles that we're seeing so far, and I think those are the key headings that practitioners can decide when determining whether there is an inevitable causation. The court then goes on to talk about a number of examples that I think we're going to come in and talk about in this webinar to help explain where that inevitable causation could be broken. And in particular, the examples were given of steel manufacture that Matt's mentioned, component manufacture for aircraft and cars, and a case which many of us will now be familiar, the Kilkenny cheese case, in the upstream effects of a milk production facility. So I know that Charles is going to come on and talk about some of those examples as well. So this might be a good opportunity to pass over to Charles, if that's okay to pick up.
Thanks very much, Imogen. I'm going to go through 16 points of distillation of the judgment, which I think are relevant to JR risk. What's the likely kind of risk going forward to projects? Where might the courts have to step in? I've seen someone's asked a question or a comment: is Finch as narrow as many commentators suggested? My overall sense, it's not as narrow, but nor is it as broad. It's somewhere in the middle, and I'll explain right now. So. The first point, I think, to get our bearings is that the need to cover direct and indirect effects isn't anything new in principle. It's in the legislation. So the EIA regs, so I'm going to focus on the regs rather than directive, given the retention of EU law act. There's a need to cover the direct effects and indirect, secondary, cumulative, transboundary, short-term, medium-term, and long-term permanent, temporary, positive and negative effects. So to some degree, nothing new. The question really is, what are those effects? What do they mean in practice? And the key message that the court delivered, as Matt and Imogen said, is this is a question of causation, whether effects are caused by a proposed development. And the lead judgment of Lord Leggett said if there's a clear and inexorable causal path from event X to event Y, then Y is an effect of X, irrespective of the number of steps along the way or where the effects might take place. Now, importantly, for the JR context, the court held by majority that the test for causation in this context is a question of law. It's not a question of planning judgment. The Court of Appeal has said it's all a matter of planning judgment. The court said, well, that could lead to arbitrary decision making because on the same facts, you get different decisions. In the context of climate change and the pressing need to combat it, that would be unacceptable. So it's a question of law. That's important because, of course, judicial review, statutory review has to be bought on point of law. There were three main options for causation. The but-for test, which is the weakest, would Y have happened but for X. The strongest variation, something to be a cause of something else, has to be both necessary and sufficient to deliver the outcome. That's the strongest thing. So if a project is both necessary and sufficient for an outcome, then that outcome is an effect of that project. And then there was a middle ground discussed, where whether the intervening act was a matter, whether any intervening act between the project and the outcome was a matter of ordinary occurrence or something extraordinary. An ordinary occurrence shouldn't negative the causal effect. In other words, if X plus matters of ordinary occurrences leads to Y, then Y is an effect of X. Now, as Imogen and Matt explained, the court didn't actually need to decide which of those three main options for the test of causation applied, because on any view, because it had been agreed that in the context of the oil extraction project in the present case, the greenhouse gas emissions from the ultimate combustion of oil were inevitable. That meant that however you define causation, if Y is an inevitable outcome of X, it's an effect of X. So that issue is still on the basis of the judgment, the question of where do you calibrate the test for causation? That's still live for a future case. The court did doubt a definition of likelihood as falling within a range of 66 to 100%. So that suggests it's lower than that. And there were some indications, I think, that the court saw the middle ground approach as probably right. But that is still an issue to be determined in a future case. So in a case which isn't on all fours with the facts of Finch, in other words, where it's not factually agreed or clear that potential outcome will be inevitable from the project, then there's a degree of risk because that may bring into question the point of law for a future case. What is the test for causation? It's clear, however, that if the highest test, necessary plus sufficient, is satisfied, then an outcome will be in effect. So if a proposed development is both necessary and sufficient for a particular outcome, that outcome will be its effect. Whether something less than that will do to mean that the outcome is effect is open to some question, but that will certainly be enough. Next point is there needs to be evidence of causation, not conjecture or speculation, as others have said. And also, next point, point number 8, there needs to be an ability to quantify or otherwise assess the effects in an evidence-based manner. So there needs to be evidence of causation, but it also needs to be capable of meaningful evidence-based assessment. Now, the JR risk here is, well, what if the lack of evidence is remediable? For example, if the decision-making authority, whether it's a local planning authority or the Secretary of State or some other decision maker, what if they could seek to cure that lack of information by seeking further environmental information? If they don't do that and then decide that they don't need to take into account potential effects, I'll call them outcomes, because they're not actually effects because there's not sufficient evidence of causation or not sufficient evidence to do a meaningful assessment. Well, if they could have plugged that evidential gap, then arguably that would be unlawful, particularly having regard to the case of Tameside, the well-established public law principle of the duty to probe in a situation where there's a potential case to answer. So those listening who are acting for local authorities need to be alive to the fact that relying on an evidential gap may not be enough where you have the power to plug that gap. Although the test for causation is a question of law, I say, precisely where it's calibrated and needs potentially to be determined in a future case, the application of that test is still a matter of planning judgment. The court made that clear, paragraph 78, where Lord Leggett said there's an area of evaluative judgment in the sense of judging whether a possible effect of a project is likely and capable of assessment, may be a matter on which different decision makers acting rationally may take different views. The reason why the court was able to quash the decision in the particular case of Finch is that given the common ground that the outcome, the greenhouse gases from combustion of oil, was inevitable, then whatever the test, no rational decision maker could say that that inevitable outcome wasn't an effect. But irrationality is not dead. Irrationality applies in the application of the legal test. Next point, point number 10. There's a lot of discussion in the judgment about different potential interpretations of direct effects and indirect effects, and a lot of discussion over the weekend on LinkedIn and elsewhere about those concepts. And the judgment's a little ambiguous, actually, the lead judgment, as to which of the two applies to the greenhouse gas effects in the present case. Actually, having reflected upon it, I don't think much matters. Actually on that, because what ultimately matters in terms of whether something needs to be assessed in the IA is not whether something is a direct or indirect effect, but whether it's an effect of any kind. So the focus needs to be on the term effect and the causative aspects of that, as opposed to whether it's direct or indirect, because frankly, whether it's direct or indirect, it still needs to be assessed. So don't get caught up in that distinction, would be my suggestion. I don't think the judgment is confined to oil extraction. Seems to me that the judgment applies to all consequences of a project where there is evidence that the causation test is met and where the effects are capable of evidence-based assessment. Now, oil extraction is probably a paradigm. Court also thought coal was a good paradigm too, but there are others, and there are two given in the judgment which may be relevant to understanding where the line might be drawn. Paragraph 90, Lord Leggett referred to commission guidance concerning the quarry of aggregates for building a new road. And the commission contemplated, and Lord Leggett thought correctly, that the greenhouse gas emissions of vehicles on that road would be effects, indirect effects, of the quarrying of aggregates. So that's one example. The other was the case of Squire, which concerned a chicken farm, which the court effectively approved. And that concerned a chicken farm where a byproduct of the chicken farm was the manure from the chickens, which was to be spread on fertilizer, including on third-party land. And the dust and smell from that was held to be an effect of the chicken farm, even though it was off-site. And the court gave that as a further example of what it saw as downstream effects. So I think those two illustrations adopted by the court show that this is not just about oil extraction, it's a broader principle. So my 12th point, the majority rejected the suggestion that its approach would open the floodgates. So it responded to two examples that Mr. Justice Holgate, soon to be Lord Justice Holgate, was concerned about in his judgment. The first was production of iron and steel. And Lord Leggett considered that the downstream effects of that would not need to be assessed at a factory for the production of iron and steel, because iron and steel have many possible uses that could be incorporated into many different types of end product, and therefore the effects of the production of iron and steel would depend upon what Lord Leggett called innumerable decisions about how the steel is to be used, how products to be made from it are used. So there's indeterminacy, he saw it as to the future use. And that also would mean it would be impossible to identify what the effects are and assess them. And a similar analysis was given in relation to Mr. Justice Holgate's example of a factory for manufacturing components for use in the construction of cars or aircraft. That there are 2 points there. Firstly, the contribution of the particular component is not material enough to the ultimate end outcome of the car or the vehicle, the greenhouse gas emissions, because there'll be all sorts of other parts that would need to be assembled together. and the use which the components to which they would be put, and the number of cars which would be produced, and therefore the number of greenhouse gas emissions, would be so conjectural when considering a factory for the component of a speedometer, for example, or some nuts and bolts, that it would mean that no meaningful assessment of greenhouse gas emissions could be produced. So again, standing back, the rejection of those two kind of floodgates points, again, can be seen as an application of the causation principle, then both in relation to iron and steel and in relation to the components of the cars, the sufficiency test of causation wasn't met, that a nut or a bolt isn't sufficient to have the consequence of the car being on the road and thereafter causing greenhouse gas emissions, and also there wasn't sufficient a basis for an evidence-based assessment of the greenhouse gas emissions. So as I say, it goes back to, is there sufficient evidence rather conjecture, both as to causation and as to the ability to assess the consequences. Then my sort of point 13 is, well, how about by way of other examples, a factory for the construction of petrol-based internal combustion engine cars rather than components? There would be, if what goes in are bits and pieces and what comes out is a car, isn't that something which is both necessary and sufficient? So the causation test is there, the car's inevitably then going to be driven, and you would be able to measure the carbon emissions from that car, not least because there are now standards, aren't there? You have to, as a producer of cars, meet certain emission standards. So it would seem to me that a new car factory may very well engage the Finch principle, subject, of course, to consideration to facts. Every case will turn on its facts. And what about a multi-storey car park? Perhaps in an area where there's a need for there's a shortage of car parking, a multi-storey car park which is specifically designed to cater for cars. There maybe need to be a consideration of modal split in terms of types of car, etc. Arguably, that may be different from a parking space in a residential development, but an ICE car factory and a multi-storey car park are probably paradigm examples. But point 14 is the court didn't, as Imogen said, it didn't undermine the established case law on the quality of a environmental statement. A long line of cases all the way up to Heathrow about establishing the principle that provided the essential ingredients of an environmental statement are provided, whether the environmental statement goes into enough detail is a matter of evaluative judgment. So that principle wasn't challenged, in my view, by the court's judge. So it may be in some cases the easiest thing for the promoter of development to do is just get on with it and assess the down. Don't argue the toss over whether you should or shouldn't assess it, but where they're very downstream, do so in a higher level. That may be the best workaround, again, depending upon the circumstances. Penultimate point I've got to make: effects outside the UK have to be considered. However, transboundary consultation under Article 7 of the EI Directive and the corresponding provision of the regulations is only required where the transboundary effects are specific to one or more particular member states, as opposed to global effects which affect the whole world. So climate change effects of greenhouse gas emissions would ordinarily fall outside the need for transboundary consultation because they affect us all equally. That may not be the case. For example, you could think of, well, perhaps hopefully wouldn't happen here, but certainly when I lived in Hong Kong and worked in Hong Kong for a while, there were particular factories in southern China where if the wind was blowing in a certain direction, the pollution would specifically hit Hong Kong. That sort of paradigm scenario probably would generate a transboundary consultation, but one must think that sort of effect is unlikely in this part of the world. And then lastly, and I do find this bit of the judgment curious, actually, in two places, Lord Legger, both paragraph 62 and 152, emphasises that the public participation aspects of EIA, incorporating the Aarhus Convention, means there's no answer to say that complying with the EIA directive wouldn't have affected the decision, which is a point that was made by the respondents, that even if we had all this information, it still would have been consented anyway. So why all the fuss, was the point made. Now, the reason I say it's puzzling is that there were two Supreme Court judgments post-Berkeley, where Berkeley had basically rejected the proposition that a no difference defence could be relied upon in the EIA context. The House of Lords then said if there's been a breach of EIA, essentially then if there's a substantive non-compliance, that the principle of effectiveness meant that a remedy had to be granted and there had to be a quashing order. And for many years that led to an understanding that a breach of EIA would ordinarily lead to a quashing order, even in circumstances where a breach of domestic law wouldn't. And the court, with a domestic law breach in equivalent circumstances, would lead the court to say we won't grant a remedy. That understanding was corrected by the Supreme Court in Walton about 10 years ago, more than 10 years ago now, and then reiterated in the Champion judgment, where the court made clear, through judgments of Lord Carnwath in particular, that the ability of the court to exercise its discretion to withhold relief where no difference would have been caused by the overall outcome, by the decision in question. That ability wasn't just a domestic law matter, but also something which could be applied in the EIA and habitats context. And so Berkeley was modified to some degree by Walton and Champion. There's no discussion of that I can see in the judgment of Lord Leggett. It's not clear whether Walton and Champion was cited to the Supreme Court. We'll see once the law report comes out, because that normally indicates which cases were cited. But on the face of it, there's a degree of tension between the judgment and Walton and Champion as to remedy in these situations. So anyway, those are my thoughts. Back to you, Nick.
Thank you. That's great, Charlie, and indeed Imogen and Matt as well. So moving into the discussion, thank you for the questions that are coming in. The first question I wanted to pick up is the first stage in EIA, assuming you're not screening, is often scoping. Post Finch, how might it now be best to approach that? Matt, could I start with you on the developer's perspective, the scoping report, and then back, Charlie, perhaps I'll come to you next on with if you've got a local planning authority's perspective, how they might engage with scoping post Finch.
Thanks, Nick. So I think the main point arising from this is that we will now in our EIA processes need to specifically deal with this issue, and I think to deal with it head on. So at the scoping stage, I think that is within your methodology chapters of that scoping, talking about indirect effects and talking about the inevitability of connections with any said indirect effects, which will mean engagement with the LPA before submission of scoping, and then during that scoping stage inevitably, and potentially with other regulators such as the Environment Agency. I think just trying to pick up on some of the questions that have been asked in the chat, there is nothing wrong at that scoping stage and then through the EIA stage, through the rest of the EIA process of taking account of mitigation. So if there are things that would be otherwise be controlled by the permit, which is a separate application, you can still reference that in deciding whether or not to how you're going to scope in or out indirect effects. There was a question about whether we think this was just taking a step back to screening, whether this judgment might lead to more developments being considered EIA development. I think my view would be no, not necessarily, because I think if you are a project that has such an inevitable connection with focusing again on likely significant effects in the indirect sphere, then you're almost certainly a project that has them in the direct sphere. We're taking account of Charlie's point that actually it shouldn't necessarily matter whether it's direct or indirect you're talking about. I think that there's a question there about precedents from previous decisions, previous approaches to EIA. I think the message there is that at that early stage of scoping and through the ES, we are now in this reality of the post-Finch judgment, and we need to take account of it no matter what was done before being a Supreme Court judgment. I think it's important to note that this is now, and I know many of you on the call will have projects that have gone past scoping and are in the ES, perhaps in the decision-making process. I think we need to be ready for the fact that LPAs, examining authorities, inspectors will be starting to ask questions around this and what does that mean, and that we need to possibly think about proactively looking to put in statements at whatever stage you're in about what you think the impacts of this judgment are on the ES that has been submitted. And I think lastly, I think that when you're at that scoping stage and at ES, I think the key word to focus on is inevitable. And that point about speculation and conjecture is not just necessarily about, is there a methodology that you can agree with the LPA, but it is also about the speculation conjecture of the inevitability of that connection. And I think that's where the Supreme Court was trying to draw a difference from what the Court of Appeal was saying, in that it's that inevitability and of in that case for the oil and gas, but more generally the question that is what needs to be asked. And I think in particular, you know, the matter of greenhouse gas emissions and the assessment of that is going to be a challenge. It's, you know, that continues to be an area of challenge, particularly like this case. And I think that we, in having this section in both your scoping report and in the ES about how we've dealt with indirect effects and establishing what's an inevitable connection, obviously having that GHG focus is going to be really important, given that it is those GHG emission impacts that are most likely to have those kind of wider indirect downstream impacts. Although, of course, I wouldn't say they're the only possibility at this stage. Charlie, if you want to talk about LPAs?
No, thank you. So, I mean, I think my point of view, there'll be some easy cases, clearly, and some at either extreme. So whenever a consequence is inevitable, as in the oil extraction paradigm, then as Matt said, it's going to have to be scoped in. Equally, where at the other end, whether it's pure conjecture, there's no evidence at all, and that evidential gap is clearly not something that can be plugged, that a particular outcome will flow from a proposed development, then there's no need to scope it in. The difficulty will be in that middle ground, and I think there's a likelihood. I was going to say danger may, but that rather suggests it's a bad thing, which it may or may not be. But I think there's a likelihood that local authorities are going to take an approach of a rather defensive and cautionary approach, given that there's a degree of ambiguity as to what the relevant test for causation is in law, due to the fact that, say, in the facts of Finch, it was obvious, whatever the test was, that there was causation. That certainly, if I was advising local authority and if the local authority's main objective was to de-risk it from a JR perspective, you'd say apply the lowest test for causation, because then no one could say that you've missed something. So I think developers and promoters need to be alive to that until a future JR determines where the bar is set, you may be pushed to keep the evidential bar for causation relatively low by the local authority to de-risk the matter. Someone's asked, would the precautionary principle apply? Potentially, yes, and that's certainly something that would have to be decided in a future case. But equally, going to the quality of the ES, I could also see some circumstances, at least, where you might scope in a particular effect, whether it's indirect or direct, a downstream effect. You might scope it in, but if it's falls short of inevitability, you might take that into account in the evaluation. I could imagine an ES chapter which grades effects, with their degree of certainty, and that may itself inform the decision. So you've taken it into account, bearing in mind, of course, in EIA, and like habitats, it's not a duty of outcome, it's a duty of process. You've taken it into account, and the weight you give it in the decision is informed by the degree of likelihood or otherwise that it will in fact be caused. So I could see that being something of relevance. That may in fact also tell in favour of a lower threshold for causation. You scope as much as possible in, but then the weight given to the factor is informed by the degree of probability.
Right, thank you both. Simon Richards has asked a question about how that the court assumed combustion, and what about the use of oil for producing petrochemicals, plastics and other products, and how did the court deal with that? I don't propose to give this to the panel because I think the answer is one that Charlie's referred to in his initial after the question came in, but it's perhaps worth just drawing attention to it. The court didn't, because the agreed facts that were provided to the courts were that the combustion of the oil was inevitable, and that is perhaps a point panelists may want to come back to in terms of, Charlie, the point you've made about likely, etc. But just to pick up that specific question, that was not one actually that the court engaged engaged with. I wanted then to pick up where other sectors and other growth areas might be, and how they might consider this moving forwards as potentially different from current practice. Imogen, could you speak from your experience of reviewing too many environmental statements and advising on those in relation to infrastructure, first of all, would be very interesting. And then Charlie, perhaps minerals or development planning might be worth coming back to. And I see we've had a question about that as well from Oliver Meek. Imogen.
Yep, definitely. Thanks, Nick. So I think this is absolutely one where it would be of benefit for EIA practitioners and people on sector by sector basis to understand and work out what those potential indirect effects could be, and interesting for any developer who's thinking we have previously defended RES from assessing such and such indirect effects on the basis that we were saying it was too remote. I think developers will need to reconsider that question. But for instance, I think on, for instance, highways, at the moment, a highways assessment will already assess the roads within an affected road network. So the increase in cars, so they are not assessing just the emissions of the development itself and the building of that new road or that widened road. They are already assessing the cars and the increased demand forecasting by the fact that you are facilitating a new road development. So from that perspective, a highways development is already assessing the increased demand from the higher number of vehicles that a road would facilitate. I think a question has been asked on the chat about an airport expansion. I think that's exactly one where now an airport expansion facility might have to look broader at the increased demands of the flights that are coming in and out of that increased facility. An interesting, a slightly different tack that the judgment itself explicitly refers to is green renewables, and the fact that there may be increased potential here to consider positive effects. So for instance, of green energy that a solar farm or a wind farm produces, and saying that is an example of, and the court refers to an indirect effect that of the green energy that the solar farm or the wind farm produces. I think that is a very interesting question for developers, because certainly the solar farms and the wind farms that we work on, the development already does include as part of its assessment the green renewable and it produces, and the green energy that's produced, and it assesses that as a direct effect. So I think that's coming back from to Charles's point earlier, that these are all just things that need to be assessed regardless. So maybe this categorization is no longer helpful. This is a question about what occurs, what is an effect of the project. But particularly from the green and the renewable energy projects that we work on, the development would already assess the positive case that is made by the green energy that it produces. So definitely one for a sector by sector case. And I think it's one where EIA practitioners, consultants, projects will need to work together to have a think again about effects that is possibly previously scoped out. They may now have to look at scoping in, but in doing that, being very careful to work through whether there's that inevitable causation, thinking about all those factors that we discussed earlier, and whether there is that inevitable causation or some sort of break in the chain.
I can just to add to that, sorry if you come in, Charlie, apologies. Just particularly because there's a question raised in the chat about this around things like new technologies and decarbonisation and CCS and hydrogen. Where there's a combination of things happening, but particularly where you're doing retrofit or where you've got the interaction hydrogen and carbon capture, that there is questions about to what extent does your installation of CCS, how does that affect how your plant currently operates, and taking that into account, and then in particular with CCS, this point around the whole cycle of CCS being, if you are an emitter that's retrofitting CCS, your carbon has to go somewhere. So there's a question there, is there's an inevitable causation between the carbon you capture and then where it goes. And so that's something that's already coming up on a variety of projects and is likely to continue to. And I think also lastly on that, I'll just make the point of there are the upstream impacts as well as the downstream impacts of being able to do the whole life cycle of those kinds of projects, where we're already getting challenged on that in examinations, and I expect that to continue. So in those spaces, I think, which is so much of what is needed as we move forward, as well as the renewables, this will be an interesting challenge to kind of work out where we draw our line. Because I would agree with the comment that in a way, if you are one emitter connecting to a pipeline that is taking on 20, how do you allocate what is your effect versus the rest of the others? But I don't think that means, and I think the judgment is clear on this, that doesn't mean that you shouldn't do it. And it comes back to the point of, particularly for renewables, but for the decarbonisation agenda, where the point of the scheme is to capture a giant amount of carbon emissions, even if you take into account, for example, carbon leakage on a pipe 500 miles away, is very unlikely to offset the positive benefit that you're bringing. And if the I know, although this might go against the principles of proportionate EIA, but if you just have the number in the ES, then you've done the process, as Charlie was pointing to before.
No, I agree. Just on the question of minerals, I think it would depend, not just necessarily mineral to mineral, but actually potentially case to case, upon whether the end output, for want of a better term, of what's being extracted is sufficiently clear. I'm not going to say inevitable, because it may be that something less than inevitable is the relevant test for causation, such as X plus ordinary occurring events, as opposed to extraordinary occurring events. But whether the test is the end outcome sufficiently clear? Because we've got, on the one hand, oil extracted, where it's inevitable that following refinery it will be combusted and there'll be greenhouse gas emissions which are immeasurable. On the other hand, we know that from the lead judgment that production of iron and steel doesn't count, because there's many potential end uses and outputs of those, each which would have different greenhouse gas consequences. But there may be things in the middle. I mean, so sort of aggregate, if that's for a particular purpose, or if it's only capable of being used for a particular purpose, then that may fall within the parameters of Finch. Equally, there may be some kind of mineral like sand, for example, which is capable of use for a range of different outputs, and there it's not possible that falls into the category of iron and steel. But even where you have got a mineral which is capable of a range of uses, if there's, for example, a contractual commercial arrangement whereby it's clear what it's going to be used for, then it may be that the relevant causative test is met by the project. I mean, for example, one thing that occurred to me is underground salt caverns, which are often used for gas storage. Typically, the salt is blasted out and goes to the sea. But I'm aware of one project where the owner-operator of the underground salt cavities has a factory some miles away where the salt is piped off and used as an input into that factory. So there's a particular commercial arrangement which narrowed down the range of potential uses of that salt. So I think it will depend both upon, as I said, what the thing being extracted is capable of being used for, and whether there's anything commercially or otherwise which cuts down on the range of things it's capable of being used for. That will inform the causation test.
And I think just to try and draw an analogy going back to renewables, is when we're thinking about where you have PPAs in place, and then going both directions, whether your supply is coming from a PPA and the effects associated with that, but also if you are, as a solar scheme or offshore wind, if you are, you've got a specific PPA, you can say that your electricity is going to that use, and considering how that is to be taken into account is something that each project will need to kind of consider on it the facts of their case.
Yeah, indeed. Thanks all. And just to make sure everyone's picked up that Matt's talking about power purchase agreements there rather than a planning performance agreement, just in case you were wondering how that might fit with the supply of electricity. I just wanted to pick up on a couple of the questions that have come through in terms of timing and whether Finch will have implications for how you're able to go through the process of, as a developer, scoping, doing your EIA, submitting the application. And I mean, the question in particular is around, might your assessment have to be delayed until the effects are capable of being assessed? What the judgment says, anything helpful on that? Or if there's an issue of a principle of development being at risk later on from once further information becomes available on an effect that wasn't considered earlier. Imogen, don't know if you want to pick up on those topics.
Yeah, absolutely. So I think as a starting point, I imagine that most projects will be wondering, what do I do now? So where I've got a project that's at any stage of pre-consent, so whether it's a scoping or early formulation, or it's in some sort of consenting process, what do we do now? And I think there will be a heavy emphasis on trying to, as Matt was saying earlier, de-risk and give comfort to your decision maker by proactively putting in your own statement of how you as developer consider the Finch judgment and how you consider that to apply to your development. So that would be a thing to do if you're at the pre-consent process, and to begin the wheels on working through that now. Imagine that a lot of decision makers will be looking for comfort and for you to give them a guide through this judgment and how it applies to your application. I think the other questions that Nick was raising there from the chat at different stages, so where information has come to light subsequently, I think the key messages to take from the judgment there are where the Supreme Court majority was at pains to emphasise that the EIA process does not require attempts to be made to measure or assess putative effects which are incapable of such assessment. So if you have a reasonable basis for saying at the point of your application or during your consent process predetermination that the information simply doesn't exist and you are unable to undertake that assessment, then that is a reasonable position, and that is what the EIA directive and process requires of you. In terms of other later stage, might be an interesting question for projects that are coming forward with, as is now increasingly popular, some sort of carbon management plan or way to show how carbon is going to be used on your development. And that plan is subject to some sort of pre-commencement discharge requirement, whether or not those pre-operation or pre-commencement plans will be used as a way and a means of updating essentially the environmental information that's before the decision maker as a sort of pre-start requirement. So it will be interesting to see whether those are the vehicles for putting more information in, because, for instance, at the point of pre-start or pre-construction works, you know a much greater or a much more refined boundary of what your GHG emissions are likely to be from those that you assessed in your EIA, because you've got your detailed design and your component parts. So there will be an interesting question of whether that is a sort of vehicle for how those updated information could be put in before a decision maker.
Right, thank you, Imogen. We've had one question which concerns the more of the substantive questions behind Finch, which I won't go into, but perhaps it does bring to the fore one of the points that is in which, Charlie, you have mentioned, is perhaps worth just drawing out a bit further, which is the role of EIA and, as you said, how that's different to the habitats regulations. So whilst what we're discussing is effects and how they might be assessed, what does that actually mean ultimately when the decision maker comes to determine the application in question?
Well, absolutely, and I mean that's where the EIA directive on its face, it leaves it to decision makers once they're taken into account. How they're taken into account is a matter for the decision maker, subject to conventional public law principles, which is why I do get the impression that where Finch will probably lead in practice is to a more inclusive approach to what goes in the ES, but perhaps a greater concentration on grading, for want of a better word, that information. So more direct effects that are more certain, carrying greater weight than less direct effects that are more uncertain, as opposed to saying something's downstream, so it shouldn't be taken into account at all. I think that's probably where we will end up. And that may well be in many cases the most JR proof approach. The difficulty is that's easier to do in smaller projects than it is in bigger projects. If you've got 160 kilometers of pylons, there may be no way of getting around, need to square up to the effects, and not simply say, well, there'll be some effects, here's 2 pages of very light touch information about it and leave it there. That may not be enough. And so I think it will probably depend, but generally speaking, I think the participation requirements tell in favour, applying Finch practically tell in favour of not calibrating the causation test too high.
Yeah. Okay. Well, that's and that picks up some of the questions we've had also about whether proportionate EIA is something that's still achievable, and also, to my mind, brings in as a relevant issue something the court spent a bit of time on at the beginning of the judgment around public participation, and that's the importance of it to the process, and whether that is helped or hindered by what may result from Finch.
Something I haven't considered, but is what somebody will have to consider, and doubtless will, is whether this reads across to habitats, where of course there is a duty of outcome, because habitats is also looking at effects, albeit through a different prism. But that can have, as I say, showstopper consequence, and doubtless somebody's probably got there ahead of me and looking at it. But the two directives have, in some ECJ cases, been held to inform one's been held to inform the interpretation of the other.
Yeah, indeed. Thank you. I think we're just about coming up to the hour. I was about to wrap up, unless Imogen or Matt, there was anything else you wanted to say that or any of the questions. Yep. Apologies if we haven't got to yours, but if there was any of those you want to pick up before we do finish.
Two really quick points I just wanted to make quickly was just, so first of all, not to forget that of course in the DCO process we have the peer stage, the preliminary environmental information report stage, and just building that point about public participation. That is a time where there is perhaps discussions to be had within project teams about how much you want to draw attention to the fact that you've come up with a suggestion about how you're going to deal with this issue, to kind of draw out any objections at that stage and help you to actually open your mind to what an inevitable causation could be. And the second point I just wanted to quickly make was, I think that this is going to be a big thing for consultants to get their head around, and I think the importance of consultants working across organisations to try and come up with agreed methodologies is going to be really important, so that we don't, projects don't try and deal with this on their own and end up being the guinea pig for more case law. And to that end, I would just note, Kieran Laxon's put in the chat that IAQM, Institute of Air Quality Management, are in the process of producing guidance on GHG emissions, building on the existing IEMA guidance. And he said if anybody wants to reach out, then email him on kieranlaxon@airpollutionservices.co.uk. I think that's a good example of the type of thing where hopefully the industry can start to look to work together to deal with the issues that Finch has now brought to the fore.
Thanks, Matt, and thanks, Nick. And there was just one final thing that we haven't really had the time to address on this forum possibly because it's worth a whole hour or more long session on itself, but it's the elements of Finch which address the role of the local planning authority in determining national policy. I imagine that particular aspect of the judgment will be subject to quite a lot of ongoing discussion, but it's worth underlining that what the majority held there, and this was a key issue of difference with the dissenting judgment, is that the fact that a local authority, in assessing something that is captured on a national level, like emissions, and addressed on a national level, the majority judgment was saying that the authority must have regard to national policy, but it doesn't follow that the local planning authority has to ignore the adverse effects on the climate, or adopt an interpretation of what is to constitute such effects that is contrary to reality. So I think it falls into the bucket for the majority of being part of a reasoned and informed decision making to have that information before you. But national policy, a whole topic in itself.
Indeed. Yeah, I think we had a debate about how long we should set for this webinar, and it could have been all afternoon. But Charlie, is there any final thoughts you'd like to impart?
No, I don't think so, other than what I am trying to find out, if I do find out, I'll post it on the LinkedIn live, is whether on the issue of public participation and whether Berkeley is back, so no scope for avoiding a quashing. I would like to, I've asked the council in the case whether Champion and Walton were cited, because it might be sometimes what happens when a court takes a year to decide something, this point is something that they came up with, and therefore council understandably couldn't have foreseen it. So it may be that Walton and Champion weren't cited, which obviously if they weren't cited, that means that a little bit less weight can be given to those passages than if they were cited. So well, I'll see what I can find out, and I'll post about that.
Indeed. Well, if 100 pages wasn't enough to be considering, then you can add in right. Those as well. So yeah, one phrase that struck me from the Supreme Court that was commenting on the Court of Appeal's approach in dismissing it, said that would have led to an unpredictable, inconsistent and arbitrary decision making. Clearly that's the opposite of what's required to achieve an effective and timely planning system, and one which allows the consenting of the energy infrastructure and all the other developments that the country needs. So I guess from my perspective, whilst having an EIA related judgment from the highest court is welcome, it's very clear from today's discussion and the range of questions that have been asked in the chat, thank you for those, and that will continue to swim around everybody's heads, that it hasn't put to bed the law on exactly what is the appropriate scope of assessment of indirect effects. I know all of us are looking forward to discussing Finch with IEMA in some cases, and with lots of EIA consultants. So if you're listening, I look forward to talking to you further in relation to particular projects and generally. Thank you, Imogen, Charlie and Matt, for your insights today, and to everyone in the audience for coming along and your interesting probing questions. That's everything from us. Thank you.